Good morning, everybody. We will start in approximately 4 minutes. Thank you. Good morning, everyone. We will get started in about 2 minutes. I see a large amount of attendees registering right now, so we'll give everybody about 2 more minutes and we will get started at 10:02. All right, good morning, everybody. For the sake of time, it is 10:02 on March the 20th, 2020. It is important that I note the exact date and time because, as you all recognize, laws and information are changing by the hour. First, I'd like to welcome you all and thank you all for attending this webinar. Today, we'll be covering the Family First Coronavirus Response Act. As we know, we've seen a lot of information and that's being put out in the media in regards to this act. And what we want to do is make sure we cover and answer all of your questions today. This morning, we have a lot to cover. Our goal is to give you exactly what you need to know about this law and how you can decide the best course of action for you and your employees. As a matter of housekeeping, we have everyone on mute. We have over 300 people that have registered for this webinar, and it's not that we don't want to hear from you. We definitely do want to hear from you. We actually do better when we're listening and answering your questions. So please direct all your questions to the chat feature on this webinar, or please email your questions to hello@highflyerpayroll.com. If we don't answer your question during the session, please do send us the question and we will make sure we specifically answer your question. So provide us with your name and an email, and we'll make sure we get back to you promptly. If you hear other voices in the background, those are my team members. We are all actually socially distant. And so, but they have been truly essential in helping put together this webinar. So I just wanted to thank Katie Jo Barber, Jeremy Riddick, Maria Mayu, and Dave and his team helping putting this together on such short notice. We have a lot to cover, so let's get started. My name is Craig Broom. I'm the president of High Flyer Payroll. Our vision is to be a national leader for payroll and HR solutions that empowers businesses to obtain and manage a thriving workforce, to exceed expectations daily and become the preferred partner of employers and business advisors. I have today a guest, David Thayard. David works for BXS Insurance, where he works with employers to develop and implement and manage high quality and effective employee benefit plans, and will work through in-house teams to help clients control cost, increase productivity, improve health through data, analytics, technology, and resources. David is an attorney and most recently served as a partner in the New Orleans office of Jones Walker. In his more than 11 years of experience as a practicing attorney, Dave specialized in labor and employment law and compliance, and also numerous client trainings focused on state and federal employment law, such as Title VII, the Americans with Disabilities Act, the Fair Labor Standards Act, and FMLA. He earned his bachelor's degrees in Juris Doctorate from Louisiana State University. Welcome, Dave.
Thank you.
First, let's cover the agenda. As I mentioned, we have a lot to cover in a very short period of time. So today what we're going to cover is the House Bill 6201 that is now enacted as law. We'll go in detail of the analysis, but hit the key point of that law, which is paid FMLA leave, paid sick leave, and employer tax credits. We're also going to talk about some FLS compliance issues that we see employers stumbling on, impacts on workers' comp, impacts on health benefits, layoffs and furloughs, and then really spend some time at the end to have some questions and answers. So with that being said, let's get started. And Dave, I'm going to go ahead and turn it over to you and talk about the paid family medical leave, emergency paid family medical leave.
Okay.
I must, before we get started, Dave, please note we do have a legal disclaimer. We are not providing legal advice, and we are not your attorneys. And so if you do have specific questions, I encourage you to get with your individual attorney, your individual tax accountant. So my attorneys say I had to say that. All right, Dave, it's all you. Take it away.
Okay, thanks, Craig. And obviously, a large focus of this webinar is going to be related to the passage of the Family First Coronavirus Response Act. Before I get into the substance of that act, one thing I have to say is, I've read at least 15 to 20 different interpretations and articles from leading labor and employment scholars and attorneys from around the country, and there are a lot of differing interpretations of this act, and there's a lack of clarity on a lot of really important pieces of this act, and this comes from very smart practicing attorneys throughout the country. And so this is kind of our interpretation of the act and some of the best practices that we think should be used during this unprecedented time. This act was signed into law on March 18th of 2020, and according to the words of the act, will become effective on April 2nd of 2020. And the part I'm going to cover of this act is the Emergency FMLA leave portion, Emergency Family Medical Leave Act portion of the act. Keep in mind that this is an expansion of the FMLA. So the total leave is still 12 weeks under the FMLA for a rolling 12-month period. It's just as it relates to the emergency FMLA leave, there's going to be some different eligibility requirements, both as it relates to how long an employee has been with the company, the size of the employer, and the reasons for taking leave. So to get started, this emergency FMLA leave portion of the Act applies to employers with less than 500 employees. Obviously, this is a big difference from the normal FMLA statute, which applies to employers with 50 or more employees within a 75-mile radius. So that's a big, this portion of the Act applies to employers with less than 500 employees. It also applies to employees who have been on your payroll for 30 days or more. Those employees are going to be eligible under this Emergency Family Medical Leave Act that has been put into place. This is another big difference. As you know, generally, employees that have been with an eligible employer for a year and worked at least 1,250 hours in that year are eligible. So again, this is another large departure from the normal FMLA. And as you know, the normal FMLA allows for job-protected leave of up to 12 weeks in a rolling calendar year for an employee's serious health condition or for an employee that is taking care of an immediate family member with a serious health condition. Under the new portion of this Act, the reason for leave has been expanded, and it specifically states eligible employees can take up to 12 weeks of FMLA leave for a qualifying need related to a public health emergency, and obviously in this instance related to COVID-19. Now, when the Act was originally drafted by the House, it included FMLA leave for people that might have been affected by COVID-19, whether they've been diagnosed, experiencing symptoms, taking care of somebody that's experiencing symptoms, etc. However, technical corrections were made, and there were much more than technical corrections. It really kind of gutted some of the eligibility requirements for employees under this new Act, and instead relates solely to child care. And specifically, this means that if an employee is unable to work or telework, which is obviously very, very relevant right now, due to a need for leave to care for the son or daughter under 18 years of age of such employee, if the school or place of care has been closed, or the child care provider of such son or daughter is unavailable due to COVID-19. So this is the only provision in place for this expanded FMLA Leave Act. Obviously, if you're in Louisiana, schools are shuttered across the state. So we know schools are out. So then the question is whether or not the employee is unable to work or telework, work from home, due to schools being out due to COVID-19. Now, keep in mind, normal FMLA is still in place. So if you do have an employee that otherwise has a serious health condition as defined by the FMLA, or is caring for an immediate family member as defined by the FMLA with the serious health condition, those requirements are still in place. Of course, the difference is those 12 weeks are unpaid, whereas there are pay consequences related to this new expanded FMLA leave for child care. Now, getting to the paid portion of the expanded FMLA leave for child care, the first 10 days of leave are going to be unpaid. And it is my opinion, and there's some differing opinion across the legal community, but it is my opinion that this doesn't go into effect until April 2nd, which the law states. And so it is my opinion that if an employee is unable to work because of childcare issues, then these rules are going to go into effect April 2nd, and the first 10 days of that leave will be unpaid. Now, like I said, there's some differing opinions out there, and between now and April 2nd, we do expect the Department of Labor to issue regulations, hopefully clearing up some of these unclear issues. However, during that first 10 days that are unpaid, an employee can substitute accrued paid leave during this time period. So whether it be your normal vacation policy, your normal sick leave policy, or the emergency paid sick leave, which Craig is going to cover next, which is for 10 days for certain reasons, including childcare, that can be substituted in that first 10 days. After those first 10 days, the remaining 10 weeks of that leave, to the extent it's needed, are to be paid at 2/3 the employee's regular rate of pay for the number of hours the employee would usually be scheduled to work in a work week. There are maximums here. Maximums that employees have to pay are $200 per day or $10,000 total per employee for this emergency FMLA leave. Now, a lot of small employers are panicking. You know, while Craig will talk about some of the tax credits later, that really doesn't matter for a lot of small employers because they may not have the liquidity, and it may even be large employers, the liquidity in place to take care of these expenses prior to the issuance of the tax credit. So one thing we do need to point out is that the Act gives the Secretary of the Department of Labor the authority to issue regulations exempting businesses with fewer than 50 employees from these expanded FMLA leave requirements when the imposition of these requirements would jeopardize the viability of the business as a going concern. Now, we're hoping that the Department of Labor in its regulations that are supposed to be issued before April 2nd, hopefully well before April 2nd, covers exactly what that means, because it is not clear yet how an employer with under 50 employees will go about being exempted from this expanded Emergency Family Medical Leave Act if having to abide by it would jeopardize the viability of the business. In addition, it is also unclear whether an employee is able to take this expanded family medical leave on an intermittent basis, like they would be able to do under normal Family Medical Leave Act leave. There's nothing in the Act which states that they cannot. So my current assumption would be that they could, because otherwise the Family Medical Leave Act is still in place. But that's unclear. And once again, hopefully some of these regulations that will be issued will clear that up. Going to job restoration, just like the FMLA, this emergency FMLA leave is job protected, and the employer has to restore an employee to the same or equivalent position upon that employee's return to work. Now, there is an exception specifically for employers with fewer than 25 employees as it relates to job restoration when that position no longer exists due to operational changes caused by COVID-19, such as going out of business, or the economic downturn, or there being that position's no longer there. There is an exception for employers with under 25 employees. Going to the next slide, and potentially some of the unintended consequences of the Act. I've seen questions: if this law applies to me, am I able to lay off employees or reduce my workforce prior to the effective date of April 2nd and avoid some of these requirements for my employees? Now, obviously, no one wants to do that, and I know many employers are wrangling their hands over what they should do here. But I will point out, although it's not completely clear as it currently stands, my answer to this question would probably be yes. The law contains no retroactivity provisions, but we're hoping once again that guidance issued by the DOL, hopefully in the next few days, will clear that answer up. But that is potentially one of the unintended consequences of the passing of this Act. And so that's kind of a general summation of the Family Medical Leave Act portion of this bill. And now Craig is going to turn to the Paid Sick Leave Act portion of the bill.
Great. Thanks, Dave. I appreciate it. So the portion, Yes.
We have a few questions before we move forward. So maybe Dave, you can answer these. The first question is kind of a two-parter. So does the Family First leave run concurrent with FMLA or in addition? And does it run concurrent with existing employer sick leave or require additional leave in addition?
So on the first question, the Family Medical Leave Act allows for 12 weeks total, regardless of whether it's under the Family Medical Leave Act that we're used to or this expanded version of the Family Medical Leave Act. So there will not be, an employee is not going to be able to get 24 weeks of protected Family Medical Leave Act leave just because of this expanded version of this act. Keep in mind, though, even if an employee runs out of Family Medical Leave Act leave for a serious health condition, there may still be ADA considerations where leave needs to be granted as an accommodation. And what was the second part of that question?
Does it run concurrent with existing employer sick leave or require additional leave?
So once again, because as it relates to the Family Medical Leave Act portion of it, I am of the belief, and this is not exactly clear, I'm of the belief that it could run concurrently with the Family Medical Leave Act portion of the bill. It cannot run concurrently, and Craig is going to cover this, with the paid sick leave portion of the bill. That paid sick leave is in addition to whatever vacation or sick leave policies are in place currently with the employer. But again, that's a question that hopefully will be clarified by some of the regulations.
And I think it's
okay,
also,
and then
I think it's important to clarify that while this is an extension, it is an extension only as related due to the need for leave to care for the son or daughter under 18 years of age. So it's specifically, this paid portion is specifically related to the care of a son or daughter under the age of 18.
And then just one more question before we move forward, and then I'll continue to keep notes of questions and make sure we get back to everybody. I know we can't answer all the questions today, but you did mention that, it's employers with 500 or fewer employees, and then you also mentioned employees who have been on payroll 30 days or more. Is that both things have to be true, or either or?
So this act does not apply to employers 500 or more. I don't know why. Maybe the assumption is those employers were already giving paid sick leave. I don't know the reason for that. So this doesn't apply to them. So it's not either or. If you do have below 500 and then the employee has been on your payroll for 30 days or over, then it would apply to that employee. Craig, you want to pick up the paid sick leave portion?
Yeah. Katie Jo, any more questions?
I have a few, but I'll save them till the end.
All right, very good. So let's talk about the Emergency Paid Sick Leave Act. And this is contained in Division E of the bill, and it requires that certain employers to provide employees with 2 weeks of paid sick time if the employee is unable to work or telework for the following reasons related to the coronavirus. It is very important. These are very important reasons, and these are the only reasons when the paid sick time requirement is mandated. The first, the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. Second, the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Third, the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. 4, the employee is caring for an individual who is subject to an order as described in subparagraph 1 or has been advised as described in paragraph 2. The employee is caring for a son or daughter of such employee if the school or place of care of the son or daughter has been closed, or the child care provider of such son or daughter is unavailable due to COVID-19 precautions. 6, the employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and the Secretary of Labor. So what we have here is they have laid out 6 reasons in which paid sick leave times are required. It's important to note that the first 2 the first 3 are to care for you or your persons, and the bottom 2, 4, and 5 are really caring for others, and kind of in the 6 is caring for yourself as well. The reason why I've highlighted these ones, the top 3 in red and the bottom 3 in blue, is you'll see that when we come into the paid section of how we are to pay and the amount in which to pay. So we're going to have to keep track of these reasons as we go through and working with our employees. So who does this apply to? First, it applies for 500 and fewer. So businesses with 500 and fewer. It applies to those that are specifically and only those that are listed in those 6 reasons. With the paid sick leave, there's no on-time exclusions. For FMLA, where you have to be there 30 days, for the paid sick leave portion, it begins immediately. And it is important to note, the Secretary of Labor can provide regulations to exclude certain healthcare providers and emergency responders from the definition of employer. What the goal is there is, obviously we're leaning on our healthcare providers and our emergency responders now more than ever. And so they have separate exclusions during this pandemic. The Secretary of Labor can also exempt small businesses with fewer than 50 employees from the bill's paid leave requirements if those requirements would jeopardize the viability of the business. That language should sound very familiar, just as Dave mentioned. So that's the same language that is in the FMLA portion. It is in the paid sick leave portion, and we understand that leaves a lot of interpretation and confusion as should an employee under 50, what do they need to do? And we expect to have something from the Secretary of Labor by March the 25th on this bill. So what do we need to do? First of all, for full-time employees are entitled to 80 hours of paid sick leave. Part-time employees, this is where it gets interesting. Part-time employees are entitled to the number of hours that the employee works on average over a 2-week period. For hourly employees whose schedule vary, the employee's paid leave rate should equal the average number of hours that the employee was scheduled per day over the 6-month period prior to the leave. What if the employee is a new employee? So if the employee did not work in the preceding 6-month period, the paid leave rate should equal the reasonable expectation of the employee at the time of hiring with respect to the average number of hours per day that the employee would be scheduled to work. Yeah, that's going to be really interesting for our variable hours employees, our part-time employees, but we will work through this. So when does it take effect? This takes effect immediately upon the effective date, which is April the 2nd, 2020. I am of the opinion, as Dave mentioned, there are no retroactive clauses in this bill. Also, when we read the technical explanation from the Joint Committee on Taxation, it is very clear that tax credits will not be effective and able to get tax credits until April 2nd, 2020. So therefore, that leads me to believe that the overall effective date of this bill is April 2nd, 2020. Also, once the employee's coronavirus-related need for using the emergency paid sick leave ends, the employer may terminate the paid sick leave. And so what that means is, as we know, we're understanding and we're learning every day that this virus typically has a 14-day quarantine period. And should the virus only impact and somebody only need 3 days then after that illness related to coronavirus, you no longer have to give them paid sick leave. This is only paid sick leave for those 6 reasons as it's related to the coronavirus. Furthermore, paid sick leave shall not carry over from 1 year to the next under this law. So how much are we looking at? So if you recall, we had those first 6 reasons. So employees who take paid sick leave because they are in those 1, 2, and 3, those top 3 categories, are subject to the quarantine or isolation order, had been advised by a healthcare provider to self-quarantine. It's key, has been advised by a healthcare provider to self-quarantine. I think there's going to be some interpretation of that because I see a lot of individuals self-quarantining and they're not a healthcare provider, or experiencing coronavirus symptoms and seeking medical diagnosis are entitled to be paid at their regular rate or at the federal, state, or local minimum rate, whichever is greater. In these circumstances, the paid sick leave rate may not exceed $511 per day or $5,110 in aggregate. So we have these other reasons. And an employee who takes paid sick leave to care for another individual or child, or because they're experiencing another substantially similar illness as specified by the HHS, are entitled to be paid 2/3 of their regular rate. In these circumstances, the paid sick leave rate may not exceed $200 per day or $2,000 in aggregate. This bill requires that the Secretary of Labor to issue guidelines to assist employers in calculating paid sick time within 15 days of the bill's enactment. So April 2nd, 2020. So how much do we have to pay employees? It depends on the reason. It depends on why they're going out. If they're going out for 1, 2, and 3, we have to pay them at their normal rate of pay. If they're going out for 4, 5, and 6 on the reason chart, then we have to pay them at 2/3 their regular rate of pay, and that's clearly defined. So what about this effect on existing paid leave? Well, in this portion, employer may not require an employee to use another paid leave provided by the employer before using this paid sick leave option. So I know some people have policies that says, oh, you have to use all your sick leave before you use this leave. You can't require this under this Emergency Paid Sick Leave Act. There is going to be an employee notice requirement that after the first work day or portion of a day an employee receives paid sick time, the employer may require the employee to follow reasonable notice procedures in order to continue receiving paid sick time. What are reasonable notice procedures? How are they defined? At this point, we do not know. However, we are waiting on the Secretary of Labor to define that in greater detail. So what are your responsibilities as an employer? Employer shall post and keep posted in places notices that the emergency paid sick leave requirements made available under HR 6201. Within 7 days of the enactment of the bill, the Secretary of Labor will provide a model notice for use by employers. That's March 25th, 2020. What we're expecting on this is the Secretary of Labor is going to post similar to your standard labor law poster. What we've received guidance on is they are going to provide us a poster and some required information that as employers, we have to make sure and distribute similar to the same laws of a labor law poster in our break rooms and in other areas. For those of you that might have a multiple and bargaining agreements, there's some specific language noted to that, some prohibitions and enforcements. Here's the thing: an employer may not discharge, discipline, or discriminate against any employee who takes paid sick leave or has filed a complaint or proceedings or testified in any such proceedings related to the benefits protections of this bill. Further, employees may not require, as a condition of providing paid sick time, that employees search or find a replacement employee to cover hours during the employee's use of this paid sick time. Employers who violate this paid sick leave requirements or retaliations shall be subject to civil penalties under the Fair Labor Standards Act. Again, what is the effective date and expiration date? The requirements set forth under Division E are effective 15 days from enactment of this legislation. So that's April 2nd through December 31st. So how are we going to pay for this? And so we understand that the paid FMLA portion and the paid emergency paid sick leave portion is going to cause a burden on employers. And so this act has inside of it employer tax credits. And this is the way that they're saying that you as an employer will help pay for this act. So this bill provides a refundable tax credit worth 100% of qualified public health emergency leave wages and qualified paid sick leave wages paid by an employer for each calendar quarter through the end of 2020. This tax credit is going to be allowed against tax imposed under the employer portion of your Social Security and railroad retirement payroll taxes. So as we know, in the tax world, the employer, you're responsible for paying 6.2% of Social Security tax against your employees. And so you pay these on a quarterly basis, and this is where your credit is going to come from. So this bill allows to take those credits and how much are you going to get? So if the credit amount for a public health emergency leave, that amount is qualified public health leave wages taken into account for each employee is capped at $200 per day and $10,000 for all calendar quarters. If you look back, that number matches that $200 per day. That number directly matches the emergency paid leave and what you're responsible to pay. The credit for the paid sick leave wages in instances where this employee receives paid leave because they are subject to the reasons that we've noted, that is capped at $511 per day. So in the instance where an employee receives paid sick leave because they're caring for another individual or experiencing a substantially similar illness, again, that's those 4, 5, and 6 reasons. It's capped at $200 per day. Again, these dollars match up. In determining the amount of an employer's qualified sick leave, wages paid for a calendar quarter, the total number of days that the employer can take into an account with respect to a particular employee for that quarter may not exceed 10 days, minus the number of days taken into account for that employee for all previous quarters. So one of the things I strongly suggest that you do is make sure that any dollar you pay for FMLA leave and for sick leave, you're keeping track of your earnings codes and your leave payments so you can apply that for your proper credit when it comes time to do your quarterly taxes. There's also a credit for health plan expenses. And this credit is there to allow the bill wants you to retain the employees. And we know by retaining an employee, that is going to increase not just payroll expenses and benefit expenses. So what this portion of the bill allows you to do is to take a credit on a pro rata amount of your paid healthcare, your employer paid health plan expenses for that employee. And so what this means is that if your employer portion of your healthcare premium is $500 and someone goes out for 10 days, you can take a pro rata amount of that 10 days over for the 500 to get a credit, and you apply that credit the same way you do the other credit on your quarterly against your quarterly Social Security taxes. So one of the things that we all know and realize is that being that the Social Security tax is only 6.2%, and if we have large amounts of employees that are taking this, is that we're going to be paying more leave than the tax. And so what the law will allow for is a refundability of an excess credit. And so what this states very clearly is that this is on a quarter by quarter basis. So we know it's going to start on April 2nd. So we're going to go through, and let's say we have individuals that take leave through the second quarter. If for some reason at the end of the second quarter, if our amount that we have paid in sick leave and in FMLA leave and healthcare expenses exceeds the amount of our Social Security tax amount, you will actually get a credit. You will actually be refunded the excess amount. The credit will not roll from quarter to quarter. That's a difference. That was what was in the previous legislation. They changed that in the final regulations. And so it is at every quarter. If for some reason, if I paid in excess of $1,000, they're stating that you will get an actual refund directly to you. So that's a very high level of paid sick leave. I don't know if Katie Jo, if there's any questions out there that you want me to address before we move on.
Yes, we have a lot of questions. The one that seems to be coming up a lot is employees who are staying home with a child. Is there any way for you to determine their eligibility for that? If they say there's a lack of school or childcare, how do you determine if that is true or not? And then also, if they have a spouse, does it apply to both people, both parents, or do they have to pick one or the other?
So that's a good question. Is how do we verify? I think what I heard with the first question is, how do we know if the employee is telling the truth? Is that kind of what you were saying, right?
Yeah,
so,
basically.
So we at this point, there's no mandate to provide any type of documentation. There's no mandate to provide any type of direct information from the caregivers. And so we encourage employers to follow your existing policies that you have in place and treat this the situation with COVID-19 no different than you would an employee 2 weeks ago. Obviously, this is a new situation where somebody's going to be staying home, but like, for example, I know that my kid's school is closed. I know that my employee's kid's school is closed. So I don't need them to go, fill out any information. It's a known fact. And so that's how I would handle that. You repeat your second question, and Dave, if you want to chime in, please could do so.
Yeah, Craig, on that one, I think a lot of this is just gonna be common sense. At a certain point, there's going to be litigation about this, one way or the other. And I think courts will not look kindly on employers denying paid sick leave based on the care for a child portion of it, because somebody didn't submit some kind of note or something like that. So I think it's really common sense. We know in Louisiana all schools are closed, and I think most employees are going to try to work, whether it be telework or in person if they can. But I think it's really kind of a common sense factor as well.
And would that go if a child has obviously two parents and both parents want to stay home with that child? Do you think the same rules will apply? I know it's not too clear in the
Greg, I haven't seen anything which makes that differentiation. I haven't seen anything wherein only one parent can get paid for this leave at one time. Hopefully there will be something in the regulations, but there has not been any guidance on that as of yet. Craig, do you agree?
Yes, yeah, I agree, and I think these rules apply to the individual employer. The stickiness comes if the individuals work for the same employer, and we just don't have guidance on that at this time. What other questions?
All right, and I'm one more question before we move forward. First and foremost, I just want to let everyone know we are not medical professionals. So today we will not be discussing how people are diagnosed, symptoms, how long it takes to get a diagnosis, things like that. I see some of those questions coming through. We will not be providing that type of information today. But Lori had a great question. If there are employees taking COVID leave prior to April 2nd, should it be assumed that this time is truly not eligible for the credit? And how should those employees be handled? I'm getting that question a lot.
Yeah, so I am going to make the assumption you will not be able to get the credit, and that's based off of some very key factors. In reading the technical explanation from the Joint Committee on Taxation, we know that this is over the quarter. So if you apply for a credit in the first quarter, the federal government will realize that you were trying to get a credit that wasn't in place. So because of the enactment of the bill on 4/2, which is the very beginning of the second quarter, I feel that you will not be eligible for a credit until after April 2nd. Do you agree with that, Dave?
Oh yeah, and I do agree with that. As it's written right now, maybe the regulations will tell us otherwise. Keep in mind as well on the paid sick leave portion of the act, that is in addition to what your policies and procedures already say, right? So if you were giving paid leave prior to April 2nd and it was based on, vacation banks or sick leave otherwise, this employee paid sick leave is in addition to that, not in replacement of, which tells me even more so that, whether it makes sense or not, as it currently stands, I don't think the credit will be available for paid leave prior to April 2nd.
And on the second part of the question, what do we do? We're going to address that at the end in the Q&A. So Dave, if you want to go through and talk about the FLSA and kind of what we see and just kind of hit those summaries really quick so we can get to the kind of the Q&A.
Yeah, we'll do. I'm gonna run quickly through these other portions. Obviously, there are Fair Labor Standards Act implications here, and as everybody knows, the FLSA governs minimum wage and overtime requirements. And with many employees working from home, teleworking, or possibly not working at all, there may be some questions out there on this. For your non-exempt hourly employees, it's kind of business as usual. The FLSA generally applies to hours actually worked. So for those hourly employees, they're getting paid for hours actually worked. With that said, it's important to press this with your current hourly employees, the need, whether they're working remotely or at work, to continue to accurately track their time and to follow all company mandated timekeeping policies and procedures to the extent possible. It's important that you press that home with your hourly employees to ensure that, first of all, they're getting paid for the hours that they worked, and second of all, there's no issues on the back end after all this stuff passes related to, hey, I didn't get paid for this time or this time or whatever. If you're allowing or suffering or permitting them to work, they have to be paid for those hours. It's a little more sticky for your exempt salaried employees, because generally speaking, as you all probably know, an exempt employee must be paid an entire week's salary if he or she performs any work during the work week. And this would include work either at the office or at home. There are limited exceptions to that, which I'm not going to cover today. If you have questions about that, feel free to reach out and ask about that. But if they work any work during the work week and they're an exempt salaried employee, then they generally have to be paid their entire salary for that work week. If they perform no work during the work week, then you are not required to pay them their salary. So if there is like a company-wide furlough or something along those lines, and it's clear there shouldn't be any work going on, then you would not have to pay the salaried exempt employees, for a work week wherein they did no work. I've seen some questions. If a salaried exempt employee does not work an entire work week, can we require him or her to use accrued pay time off? Some recent DOL guidance, and when I say recent, within the last week in response to all this, states that when an employer offers a bona fide paid vacation policy to its employees, generally speaking, the employer is not prohibited from requiring the employee to take such paid leave on a specific day. So it appears as though the DOL has loosened up its restrictions there as it relates to salaried employees and whether or not, you can require them to take vacation on a certain day. But still, if they work at all during that day, you shouldn't be deducting from their vacation bank, generally speaking. In addition, if that salaried employee is out of accrued vacation or has none, and he or she is doing any work during that work week, you still have to pay them the entire week's salary for that work week. So those FLSA requirements are still in place. And there's a pretty good Q&A section under the COVID-19 response by the DOL on their website. If you kind of want to look at further questions there, that might clarify, some further questions you have.
Can I ask you one question really quickly? A lot of people are asking if their business is shut down by the government, the dentist office, the people with government contracts and things like that, do all of these rules still apply to them?
Well, if they're shut down by the government, they literally cannot operate. I mean, Fair Labor Standards Act rules would still apply. Let's say if an hourly employee is doing work at home, per your direction, and you're suffering or permitting them to do work. But if truly nobody is working, then there shouldn't be any FLSA implications unless during that work week the salaried employee works some amount of time. But if they're truly shut down, there's no work going on at all, then you don't have to worry about it. Now, my understanding is if there is a shutdown and offices are shut down, that wouldn't preclude businesses from continuing to operate remotely, from people's homes or whatever. And if that is still the case, then these rules are still going to apply, yes.
Why don't you touch on workers' comp, Dave, and how this, what we're hearing about, some high level thoughts on workers' comp.
Yeah, some workers' comp implications, and this was more in the past 2 weeks. If I have an employee at work and they allege that they contract the coronavirus at work, is that going to set off my workers' comp policy, and they would possibly be entitled to workers' comp benefits? Under the workers' comp statute, there has to be an accident or an occupational disease in the course and scope of an employee's employment. An occupational disease means only that disease or illness which is due to causes and conditions, and this is important, characteristic and peculiar to the particular trade, occupation, process, or employment in which the employee is exposed to such diseases. So what if an employee submits a workers' comp claim stating that he or she contracted coronavirus while working and within the course and scope of their employment? Based on Louisiana law and case law that I've previously studied a lot, unless that employee's position has characteristics or peculiarities particular to that trade that would otherwise expose the employee to the COVID-19 virus more so than other positions, it's my opinion that the contraction of the coronavirus would generally not be covered by workers' compensation. As an example, if somebody works in the medical field and it's pretty certain that they contracted the coronavirus while caring for patients or whatever, I think those individuals would have a valid workers' comp claim. If you're in construction or in an office setting or something along those lines, those settings don't generally, lend themselves more so than others to the contraction of something like the coronavirus. And so while there still may be workers' compensation claims made, it's my opinion and the opinion of some other workers' comp attorneys that I've spoken with that they'd face an uphill battle there. On top of that, I think it would be hard for those employees to pinpoint exactly where the virus came from, whether it would be work or elsewhere. And so those are just some of the high-level workers' comp implications that some people have been talking about and our opinions on those.
So Dave, we know a lot of people are laying off workers. We're allowing a lot of people are furloughing workers. Can you tell us a little bit about what the impact on health benefits as it relates to furloughs and layoffs?
I can, Craig, and also I have my colleague, BJ Brannigan, who's also an employee benefits consultant with BXSI in here with me, and he'll be able to lend some guidance here as well. So generally speaking, for employees who continue to work, whether it's at the work site, facility, or from home, and have a pretty regular work schedule, those employees shouldn't see any disruption to their benefits. That should be, business as usual. When we get into some of the issues is, like you said, Craig, where have employees on leave or are furloughed. And generally, whether or not those benefits continue business as usual is going to depend on a lot of things. It's going to depend on the plan documents. It's going to depend on the employer's normal leave policies. And those things may differ by plan, carrier, or funding structure. And what we're hoping to see is that carriers are going to be willing to work with employers and employees, in expanding or providing some reprieve for these laid off or furloughed workers. And generally what we're seeing so far is that they probably will be doing so. And so moving on to the next slide, when you're a fully funded benefit shop, eligibility is generally going to depend on the plan documents and your leave policies. And so if you as the employer or the plan sponsor, you need to review those documents carefully. Talking about the insurance carriers and flipping to the next slide, and what we've heard from some of the main insurance carriers, and again, I'm just providing medical. You have to keep in mind other products, whether it be dental, vision, disability, life, etc., those requirements as well. But as it relates to kind of the major medical carriers in our area, for example, Blue Cross has basically told us that if you consider an employee to still be an active employee, even when they're furloughed or they're taking some kind of leave, then they're going to consider that employee to be an active employee. And so they're going to continue to allow coverage of employees through this crisis as long as the group considers them employees. Now, one thing that Blue Cross pointed out this morning, which one of my colleagues, Natalie, sent an email to, is stating, like, if you do lay off an employee and they go into the COBRA or state continuation realm, even if you as the employer are continuing to pay the employer portion of the premiums they're not going to consider that to be an active employee. So that will still be COBRA or state continuation kicking in, even if the employer is paying some of those premiums or benefits.
One thing I'll just add is, there's obviously a difference between a furlough and a layoff. A true layoff is where they're stating that COBRA or state continuation would be the option to retain coverage. If you're reducing hours or having going down to no hours temporarily through a furlough, then there's some flexibility there. So a reduction of hours, there's some flexibility. It is carrier dependent. You are in a situation where some carriers have stated that to be proactive, it might be best to submit on company letterhead a request to reduce the hour requirement for benefits. So this is obviously going to be very fluid, but it's very case dependent on whether that coverage would remain active and those employees would be considered active versus whether that employee would have to take advantage of something like COBRA or state continuation due to a specific layoff.
Okay. And kind of going on here, I know we need to wrap up soon. Of course, it's possible legislation is going to be passed at some point related to furloughs and benefits plans. But until then, be proactive with the carriers in order to change any of those eligibility requirements on the employer side that you may need to do. Otherwise, if your employees are terminated or laid off, COBRA and state continuation requirements are still in place. And keep in mind, payment requirements are still in place. So even if a employee is on COBRA or state continuation, they have to continue to pay their premiums, or otherwise it is expected that coverage is going to be canceled. And obviously nobody wants to see that at this time. So make sure that you have a plan worked out, especially if there's a furlough or something along those lines where, employees are not getting regular paychecks and their pay can't be deducted. Make sure there's a plan in place there as to how those premiums are going to be paid. Real quick, moving on to, self-funded plans, you have a little bit more flexibility there because you're kind of controlling the claims portion of that plan. But keep in mind, your reinsurance carriers may have certain eligibility requirements themselves. So make sure you check those out as well.
So a couple things that, as I know that we are coming up close to 11 o'clock. We are going to stay on the call and answer any questions that you may have. I know we said we would run till 11, so we'll honor that. But Dave and our team and I will continue to stay on the call. If you have any questions, we're happy to help. So obviously there are some very practical concerns for employers that are noted here. There's also items that we didn't cover, which is unemployment insurance. Every state is moving aggressively to remove restrictions. And so I encourage you to check with your own independent state in which you're located around unemployment. We know there's policies and agreements. COBRA administration, we kind of just breezed through that. I will be sending out a copy. We are recording this, and so you will get a full recording and the actual slide deck. I encourage you to go to our website at highflyerhr.com, COVID-19 updates. We're posting, we have sample furlough agreements, anything and information there. It's all, things that we weren't able to cover in great detail. I'm
also recording all of the questions that are being asked today, and we will send out a document this afternoon with all of those questions answered. So if we don't answer your question during this call, it will be answered today.
So let's, with the remaining time, David, we could just kind of hit Q&A that I know that we continually hear. And one of the things that I see here, the biggest question is that what is the difference between a layoff and a furlough? And what should I do in the next what should I do in the next 2 weeks? And really my advice is that's really a complete independent business decision. It's a kind of a good faith decision, but also a financial decision in protecting your own business. For me, if you want to protect the employees and retain them for those dentist offices that we know that we have a 30-day window and we want those employees to come back, traditionally maybe a furlough may be better because the conditions are that those benefits are going to be retained. And an employee in every state has noted that they can collect unemployment while on furlough. However, they can't exceed their normal than 100% of their wages. If you want to, if your business is just really in financial despair, then a layoff, because that ends all payments and all employer responsibilities immediately. And then you can always rehire the individual. Dave, you want to answer any kind of questions that you consistently are hearing?
Yeah, and BJ is going to just say something about a furlough real fast.
Yeah, Craig, I would just say, just for clarity around what a furlough is, it's, requiring employees to either work fewer hours or take a certain amount of time as unpaid. And as you kind of mentioned, that's more of a temporary situation, whereas obviously a layoff feels a little more permanent than what a typical furlough is. So I think it's just from a strategic perspective, a furlough is, to think of it is more temporary, either minimum reducing hours or time off.
Kitty Joe, any questions that are coming in that we can continue to answer.
Yes, we have lots of questions. Let's see. One just came in. If we furlough and cut hours, can the employee collect unemployment for those hours or only if completely not working?
That's a good question. Each state is changing their own independent regulations. At this point, the majority of the states are saying that you can collect unemployment for a difference of hours because of this pandemic. But I would suggest you go to your independent Department of Labor in your state and identify that, because some states haven't adopted that just yet.
Right.
Okay, I've gotten a lot of questions around FMLA. If someone has already used either part or all of their FMLA time in the last 12 months, are they still eligible? And then a second part of that is, can FMLA and sick time be used intermittently if someone's child only has care 3 days a week or something similar to that?
Craig,
Yeah.
follow me up on this, but
Yeah.
it's my understanding that this expansion of FMLA, it's still a total of 12. It's still a total of 12 weeks total during a rolling 12-month period for a given eligible employee. So it's my current understanding that if the employee has already used 12 weeks of FMLA, there is no requirement to grant an additional 12 weeks of FMLA if they're out of that FMLA, during that same rolling 12-month time period. That may be addressed in the regulations, and that may be changed, but that is my current understanding. Craig, do you agree?
I agree, and it's just under the logic. Keep in mind, this is an expansion of the existing FMLA, and a lot of the wording in the bill refers back to the language in the original in FMLA, and so I agree that.
And as it relates to intermittent, there is nothing in the FMLA portion of the bill which does not allow intermittent for the child care purposes of FMLA. And so I am working off of the assumption that intermittent leave would be allowed for the child care portion, for the child care specific FMLA leave, based on the availability of providers, care providers, et cetera. Originally, when the bill was drafted, I've seen some articles and notes that there was going to be a prohibition on intermittent leave. However, that was removed, which leads me to believe that intermittent leave would still be allowed on the FMLA front. On the sick leave portion, because it's not FMLA, there's been nothing addressing whether or not it can be used intermittently. With that said, as Craig noted, once an employee gets back from sick leave, and the sick leave that would be specific to COVID-19, the sick leave is considered ended at that point. And so that would lead me to believe that would all have to be used together at one time. Again, it is not clear, and hopefully will be wrapped up in some of the regulations. But because when an employee returns from sick leave, the sick leave is considered to be over, it would be my belief that could not be used sporadically or intermittently. Because if you have any of these issues related to COVID-19, you shouldn't be coming into work anyway. And so that's my belief as to how it applies.
I agree, and also keep in mind, but in this bill, it is very clear that it does sunset on December 31st, 2020.
Right.
What else, Katie Jo? Any other questions before?
Yeah, someone asked, to cut costs, can we cut salaries across the board for all salaried employees? For example, all employees would take a 10% cut to their salary.
You could do, it's in my belief, you could do that. For example, I've heard of some people going from a 5-day work week to a 4-day work week, right? And so they are cutting salaries of exempt employees by 20% in order to face that new reality. I'm of the belief that, yeah, you could cut that just like you could at any other time due to an economic downturn or otherwise for exempt salaried employees. With that being said, you have to make sure that you're still meeting the weekly minimum salary required under the Fair Labor Standards Act, even if the salary is cut and even if the days are cut, in order for that employee to keep his or her exemption. On top, with that being said, on top of that, though, I guess, if you're cutting the work day, if you're cutting the work week to 4 weeks, there's probably not a lot of chance that employers are going to be working over 40 hours. But you just have to keep all of those implications in mind. You probably can cut salary for exempt salaried employees, but they still have to be paid at least the minimum as currently required by the DOL. I don't have that in front of me. I believe it's in the $658 range per week, but please check that for me.
Yeah, and my advice on that is, as long as we're making these decisions that don't reasonably violate any of the other, federal laws, whether it's the Fair Labor Standards Act or Department of Labor, Title VII, that as long as that we're making them consistent and no one can imply that we're discriminating based upon Title VII, race, religion, age, gender, those traditional laws, then 100% absolutely take care of your business.
We also got a question from Harmony about commission-only employees. Sales employees for car dealerships, for example, are being sent home, so they are not getting paid. Should they be filing for unemployment, and what is the best practice there?
Yeah, that's commission-only employees it's an interesting scenario there, and in those scenarios, we have to refer back to the language. It says your normal and otherwise reasonable pay practices that were before this went on. And so, what would you do 2 weeks ago or 3 weeks ago if there were no sales? You would send people home, and in this case, yes, they can collect unemployment.
Amy had a good note that I just want to put out there for everyone to hear. If you are going to cut salaries, like that example we used earlier, just cutting everyone by 10%, keep in mind the ACA implications on affordability. So that is something,
good point.
A great note, Amy. Thank you for that. Craig, some of the questions that you have up on the slide, a couple of people asked if you would answer those questions. So any of those that you haven't hit, can we cover those?
Absolutely. So, if the law is effective until 4/2, what do I do? I think I kind of already pointed that out. What if the employee is not sick, but we were mandated to close the doors for a month? What do we do? That is, again, independent business decision. Their protection under these particular provisions will be effective on April the 2nd. And again, just keep in mind, if I lay someone off today, I terminate them prior to 4/2, you're released of certain responsibilities. If I furlough them, I'm technically retaining them as an employee, and so then some of these responsibilities will be included. So it's important you understand the difference between a layoff and a furlough. Can my employees refuse to come to work and to travel? The answer to this is it depends. And so if the employee feels that their work environment is unsafe, they are protected under OSHA, currently under these regulations. And so in those situations, I would really just try to work with your employee. We're in an area of unknown right now. But if you can 100% prove that you're in a safe work environment, but ultimately the answer for me is yes, unless there's some proven unsafe work environment that is out there. Dave, you want to chime in on that one?
Yeah, so that also is going to depend on industry, right? Like if you're a medical provider and your nurses don't want to come in because they don't want to contract the disease, and they're in some kind of emergency situation, or they're with some kind of provider that's providing care, that's completely different. I think they have to come in, and I think there's probably some kind of obligation under certain medical oaths, which I'm not familiar with. But it's my opinion that until there is a complete shutdown, and if there's some reason that the employee has to be there and they can't function without it, that may change the application as well. But that's really going to be a case by case basis, like Craig said, and as much as you can work with the employee, do so, especially if they're able to work from home at all.
So next question, can we send employees home if they're symptomatic? Kind of similar, if an employee is out due to sickness, can we ask about their symptoms? Thankfully, the EEOC did release yesterday a brand new set of guidance as it relates to the ADA and COVID-19, and as an employer, what you can and ultimately what you can't do. Thankfully, what they've said is that you absolutely, if an employee has any type of symptoms as stated by the CDC, you can immediately send them home for a period of 14 days. Can you require the employee to verify that they don't have the coronavirus before returning to work? Yes, you can do that. Can you give somebody's temperature at the door, which is a medical test that as employers we traditionally couldn't do because of the World Health Organization said this was a pandemic, that the EEOC said absolutely yes, you can take employees' temperatures. Can we ask about their symptoms? Now, we can ask about their symptoms, and this is where I would craft my language very clearly, that I'm asking about the symptoms as it relates to COVID-19. So, for example, we know the stated CDC symptoms as COVID-19. So if I'm talking to the employee, I'm going to say, do you have these things? Also, keep in mind, HIPAA is still in effect. And so I cannot go around the office talking about one employee's condition to another employee's condition. So I would violate HIPAA. I cannot put on an email, hey, nobody go into marketing because Sally has COVID-19. We cannot name the individual, so be very cautious that we respect HIPAA. The other one, which is really interesting, is may an employer delay the start date of an applicant who has COVID-19 or symptoms associated with it? Yes, we absolutely can do that. It is our job to provide a safe work environment. On the same note, may an employer withdraw a job offer when it needs the applicant to start immediately, but the individual has COVID-19 or symptoms of it? Again, based on current CDC guidance, this individual, actually, they can't safely enter the workplace, and therefore, the employer may withdraw the job offer. Let's say, what if my employee discloses that their family member or roommate has COVID-19? I immediately say quarantine those individuals for 14 days. What if I have a fearful employee who just refuses to come to work? David, you want to touch on that one?
Yeah, fear alone is not going to be enough to refuse to come to work. Again, especially in the medical setting. As you just touched on, Craig, employees are entitled to a safe workplace under the OSHA regs. And so that fear would have to be, related to that. But, fear alone is not enough. But again, we are encouraging employers during this unprecedented time to work with your employees as much as possible, and to use common sense. But fear alone is not enough to not report.
Greg, I have another question Hunter sent on behalf of one of his clients. If we have to shut down and are not paying our employees, when I pay our premiums for benefits, how do I recoup the portion of the premium that the employee usually covers?
and this was something we touched on a few minutes ago. You're going to have a plan in place. And so maybe there's an agreement between you and the employee that, all right, we'll cover the portion up front and we'll recoup it later from you, whether it be some additional deductions while keeping in mind Louisiana deduction laws, or, we need you to send us a check to cover this portion by X date or whatever. There's going to have to be, again, another administrative headache. There's going to have to be a plan there, and BJ is going to add something.
And typically with a plan, if there's no deduction, money to deduct or enough to deduct, a lot of times when employers are setting a plan, there's a requirement either monthly to pay the premium in a set timeline, whether it be 30 days. Rarely does it go further than that. 30 days, 60 days leeway before coverage is terminated. So, yeah, I mean, you have to be crystal clear. You have to have a timeline around how premium would be due, and execute that plan consistently across the board.
I got a question from someone just asking to touch more on whether companies are exempt if they have under 50 employees. Again, this is the bill has specifically allowed the Secretary of Labor to craft regulations and to make the determinations as to whether employees under 50 are going to be exempt from this. That's going to be in the regulations. That's really all I can say from that. I've seen some literature out there based on some technical corrections that even if employers under 50 are subject to the FMLA or the paid leave, sick leave act, they're not going to be liable for any civil violations. I don't know yet if that's true, and I'm hoping that the regulations will clear that up. But I have seen some literature about that possibility, which would obviously, make a big difference, and would cause the act to lose a lot of its teeth, at least for employers with under 50 employees.
Great. What other questions, Katie Jo?
As it relates to delaying, sorry, it scrolled on me. As it relates to delaying start dates and withdrawing job offers, does this apply to someone who has completed 2 hours of training and completed all hire paperwork, but then could not report the next day due to their spouse having symptoms? Should we delay his start date? Or are we legally allowed to just withdraw the offer?
Good question. I would go to your definition of when their start date is. And so if your start date has traditionally been defined as the day they start training, then that individual is technically your employee. They won't be eligible for the paid family leave because they don't meet the 30 days, but they would be eligible under the paid sick leave portion. I would identify the reasons under those six reasons that were given, and then follow the compliance with that, the paid sick leave portion.
Keep in mind as well that we're an employee. Louisiana specifically is an employee at will state, right? And so generally you can pull a job offer, if it's not related to unlawful reasons at any time. There could be some potential detrimental reliance issues there if you did that. What I would say is, at the very least, based on the guidance we've seen, you can absolutely delay the start date, and we'd probably recommend doing that. Whether or not you could withdraw the offer in total because if it was because of the spouse's symptoms or sickness, that's another question. It wouldn't be covered by FMLA because that wouldn't be related to it wouldn't be covered by expanded FMLA because that's not related to child care, and that employee wouldn't otherwise be covered by the FMLA because they haven't been there for a year or worked 1,250 hours. Theoretically, there could be some Americans with Disabilities Act issues there, and specifically an associational claim. You are associating an employer, an applicant with somebody that has a disability, and you withdrew the offer because of that. So I would tread lightly there. But at the very least, you can delay the start date for the for the applicant or the employee because of the spouse's diagnosis.
What other questions, Katie Jo?
Okay, someone is saying, I have an employee that has already this week applied for unemployment due to not having childcare. Do I need to have that person come back in and fill out FMLA paperwork? Does she need both?
So at this point, there's no really guidance on what paperwork is going to be necessary. What's the exact language? As they say, what is it? Reasonable. As far as on the notice, the information.
Right. Generally, I mean, because of the situation, to give reasonable notice as soon as possible, I would consider this come April 2nd to be reasonable notice. Now, what's not clear from the question is whether or not the employee is quitting or getting laid off or whatever the case might be. But I think this would be considered reasonable notice as required under law, because like as Craig said, we don't know yet if there's going to be any paperwork requirements for the expanded FMLA leave specific to childcare.
Good question. What else?
So in reference to that particular question, this person is saying the employee is out on PTO and she needs to be home with her child because she does not have childcare. So I'm not sure if that information.
So it looks like it's still an employee of the company. He or she is taking PTO that they already have right now. I would think that this would be considered reasonable notice, and as it relates to the need to stay home for childcare purposes, and come April 2nd would then be able to take that 10 initial days of unpaid FMLA leave, but which will probably be filled by the 10 paid days of the expanded of the paid sick leave, and go from there. I would think that would be considered reasonable notice and should probably be considered enough at this point for the employee to be able to take that protected leave as of April 2nd.
Yeah, I would say I agree. In that scenario, the employee would be eligible for FMLA effective April 2nd to care for the child. The first 10 days would be unpaid. They could supplement that time due to Section 5 on the paid sick leave requirement. They would be paid at 2/3 their rate because that's what for that particular portion for 2 weeks. And then they would go on to the paid portion of FMLA at 2/3 their rate. It still remained to be unseen how unemployment insurance and these paid leaves and what they're going to mandate and how they're going to coincide. But what we do know is there is information to come on how that's going to be regulated.
I have a couple more really good questions, and then I know we're kind of approaching the 1.5-hour mark, and so I do want to assure everyone we will answer your questions in an email this afternoon, but a couple more really good ones. Deanna is asking, what if they were in a position that did not accrue sick leave? Would the FMLA sick leave payments still need to be paid?
Yes. And then in that section, that typically is what we find is our individuals that are part-time. And so then where that position is a part-time employee. And then what we have to refer back to is how do we identify the amount for that part-time employee? And that gets to this kind of definition here that's on the screen.
Yeah, this paid sick leave is in addition to whatever PTO vacations are already in place. So if there's none in place, then it still applies.
Catherine asked, can you lay off some people and furlough others?
Generally, you can, but this is going to go back to kind of normal employment law. You have to do so on an objective basis, right? And you got to be careful because you got to make sure you're not doing so on some kind, even if it's, you know, unconsciously on some kind of protected characteristic, whether it be age, race, sex, whatever. And so you can, but it's just like any other situation. It has to be done on an objective basis, and on top of that, you start to worry a little bit about disparate impact. So making sure, even if it is objective on its face, it is not overly impacting some group with protected characteristics, you know, more so than others. So you can, but make sure it's done consistently and you know, in compliance with other normal Title VII, ADA, ADEA, those types of acts as well.
One of the questions
Great.
that was asked on my screen is, you know, how does this apply for under 25 employees, and does this new FMLA law affect them? You know, the answer is yes. We are waiting that Secretary of Labor to give us some sort of definition on what does it mean, you know, for that to be kind of impacted, and there's exclusions for the 50 or less. But on the 25 or less, the job restoration, if you're 25 or less, you are exempt from job restoration only. You still have to comply, but pay attention to what's going to come out, I think, by March 25th from the Secretary of Labor on what does a 50 employee or less company have to do to prove that they would not be eligible. Okay, Joe, what else?
We are at the hour-and-a-half mark, so I think we've answered a lot of the big questions. I definitely will, like I've said several times, collect the rest of the questions and make sure that they are answered and sent out to everyone, so everyone will have all of that information. Last question, I did just get one. If we lay off to get to under 50 employees before April 2nd, can we get in legal trouble?
The potential is there, because I have to look a little bit, and this is something we could follow up in our questions and answers on. I have to look a little bit at what the counting mechanism is going to be as it relates to employees. It may be like a look back, and it's probably not going to be a snapshot of where you are as of April 2nd. It'll probably be some kind of look back, whether you had 50 employees over the previous 20 work weeks or 50.
That's what it is, Dave. That's what it is in the law. It is a look back over if you've had you know, more or less than 50 employee in the preceding 20 work weeks. It follows the same standard legislation.
And also we have to keep ACA in mind there as well, because as BJ just reminded me, it's the prior 12 months, correct?
Yeah, it's the calendar year that we use to calculate for AL status, so for ACA purposes. So that, you know, an immediate drop in employment would not necessarily, if you're 50 or more, would not necessarily impact your ACA status.
Yeah, and I would encourage in those situations, again, what you do today is a lot of the way it's on a previous 12-month look back on how they define you. Okay, anything else, Katie Jo, before we wrap up?
We are good.
Okay, very good. Well, once again, thank you all for tuning in today. Thank you, Dave. I really appreciate the information. We will be sending out recordings of this webinar, as well as sending out the slide decks to everyone that has registered. If you have any questions, you can email us directly or email them to hello@highflyerpayroll.com, or always go to our website or the BXS Insurance website, where we both have great resources to help you as employers. So thank you today, and we look forward to staying in touch. We will be having additional webinars on key topics once we get information from the Secretary of Labor explaining some of the guidance that is issued, and we'll send those out as well. So thank you. Have a safe and happy day. Take care.
Thanks, Craig. Good luck to everybody. Thank you.